All right, well, we have a lot to get into today, so I think we're going to go ahead and get started. More people will be joining us as we go, but welcome everyone so much. I'm so glad that all of you could join us today. My name is Ashley Westby. I'm the program director for the National Employment Lawyers Association. Welcome to this overview of the Federal Pregnant Workers Fairness Act that was recently enacted. The PWFA really holds the promise of making the workplace fairer for women, people of color, and low-wage workers, and holds the promise of ensuring that pregnant workers are not forced to choose between their economic security and their health and the health of their children. It really is a piece of landmark workers' rights legislation, and we are thrilled to be able to offer this briefing today. Today, we're going to provide an overview of pregnancy accommodations and the new law, and talk about how to advise employees who need pregnancy accommodations. I am so grateful to our presenters today. We have Jillian Thomas, who's a senior staff attorney at the ACLU Women's Rights Project, Liz Morris, who's deputy director of the Center for Work-Life Law, Vanya Lavelle, who is the senior legislative counsel for the ACLU, and Cynthia Calvert, senior advisor to Work-Life Law. The bios for the presenters are in your handouts, and the handouts are available for the email that you sent, and they are in the chat right now. So you can go ahead and look at the link in your registration confirmation, the materials email that was sent earlier, or out of the chat. It also has a copy of statutes, a list of resources, and additional materials. If you have any difficulty downloading these documents, you can contact me. I will put my name in the chat along with Pedro Valverde. So I also want to let everyone know that we do have closed captioning for this briefing. If you look at your bottom bar, you will see the closed captioning option. If you need closed captioning, please go and choose show captions now. If you have any questions or comments during the presentation, please use the Q&A window instead of the chat window. We're going to try and answer some of them in writing as possible during the briefing, and then we're going to have a Q&A section at the end of the program. The program today is being recorded, but the Q&A at the end will not be. So if you're watching the recorded version and you have questions, presenters encourage you to reach out to them directly via email. We're excited to say that this is the first in a series of webinars and resources about the PWFA that will be co-hosted by Work-Life Law, the ACLU, and NELA. We're envisioning these webinars and will include a discussion of key legal issues, litigation tips, and along with sample pleadings and other materials. But we want to hear from all of you about what topics and resources would be most helpful to you in your practice. So please keep an eye out after this webinar for a short survey for your input on future programming, or feel free to drop your ideas in the chat or email me directly. In the meantime, if you decide to represent an employee in a PWFA matter, we encourage you to get in touch with any of the presenters here from Center for Work-Life Law or the ACLU. Their organizations are excellent resources and great friends of NELA who are experienced in providing technical litigation support, and they're happy to talk you through any of these matters, including helping a client to get an accommodation that they need or developing litigation strategies. You'll also be helping their teams to keep on top of what's happening with the PWFA in the workplace and in the courts. Their contact information is in your handouts, which again, we will be putting in the chat again. In addition, if you're contacted by a potential plaintiff, you're not able to represent them, please make sure they have the contact information for the Center for Work-Life Law's free employee hotline. That's also in your handouts. Services are available in English and Spanish with additional languages upon request. The helpline assists workers by making sure that they know their rights. They also assist with making accommodation requests, and when necessary, can put workers in touch with lawyers in their areas who can represent them. If you want to be one of those lawyers in Work-Life Law's network who's contacted when an employee needs legal representation, please contact Cynthia Calvert, one of our excellent speakers today. We're lucky to have our expert panelists with us. Truly, the ACLU Women's Rights Project and the Center for Work-Life Law have been at the forefront of advancing legal rights for pregnant, postpartum, and lactating workers. Our speakers have decades of experience counseling these workers and litigating their accommodations cases. Our first speaker, Vanya Lavelle of the ACLU, was an important national leader in the successful fight for passage of the historic new legal rights we're here to discuss. So with that, I am going to turn over to Vanya.
Hi, thank you, Ashley. Let's see, I think we can go to the PowerPoint screen 1 at the moment. Great, thank you. So again, my name is Vanya Lavelle. I'm the women's rights lobbyist at the ACLU. I'm happy to be here with all of you to talk about the Pregnant Workers Fairness Act. I worked on this legislation for 10 of the 15 years that I've been at the ACLU, and it's hard to describe the joy we all felt when President Biden signed the bill into law. It's been an incredible and at times harrowing journey to get this legislation over the finish line. It had been decades since Congress passed a pregnancy discrimination law, and given the ideological divides on Capitol Hill, it's been almost impossible to find common ground on these issues. But over the last few years, we built a powerful coalition that used every tactic in the book and simply refused to give up. And by the way, that's on your screen. That's a picture of me with my homemade PWFA sign that I stayed up to 2 o'clock in the morning working on the day before our Capitol Hill rally in December. And again, it has just been an incredible but harrowing journey. Next slide. So I have to name the extraordinary champions and supporters in the House and the Senate that helped us get this bill passed. So we're looking at Senator Casey, Senator Cassidy, Murray, Burr, and Representatives Katko, Nadler, McBath, Herrera, Butler, Bobby Scott of Virginia, and of course, Speaker Pelosi, Leader Schumer, and even Leader McConnell. So I'm happy to report that on May 14, 2021, PWFA passed the House by a vote of 315 to 101. And we hadn't seen those kind of numbers in a long time. And it passed the Senate on December 22nd, 2022 by a vote of 73 to 24 and was signed into law on December 27th. Next slide. So one of the critical pieces of our legislative strategy was to educate members of Congress about why we need PWFA. Oh, by the way, some people say PWFA. I can't help it. I've been saying PWFA for years. It irritates some people, but so forgive me. But we needed to educate lawmakers about the need for PWFA, and we needed to focus intensely on the 10 Republican senators to support the bill, because as you know, you need 60 votes to pass anything in the Senate. So we reminded them of the many physical and mental changes pregnancy causes. For example, in the early months, pregnant workers may feel fatigued and nauseous. In the later months, your center of gravity may shift. The increased weight may cause swelling and pain in your feet and your back, maybe harder to breathe. But fatigue may return later on in the pregnancy. In addition, there are pregnancy complications that occur, right? Like bleeding, gestational diabetes, high blood pressure, heart irregularities, and perinatal depression and anxiety. Next slide. We also shared with lawmakers the stories of pregnant workers across the country, particularly those in low-wage, male-dominated, and physically demanding jobs who needed simple accommodations, simple and temporary job modifications, often recommended by their doctors, that would allow them to maintain a healthy pregnancy and continue earning a paycheck. You know, in my job as a lobbyist, stories, and obviously stories from, you know, the states where the member lives, are one of the most important tools to getting legislation passed. So, you know, we talked about Michelle, an EMT in Alabama who couldn't lift more than 50 pounds and sought a desk job in the dispatch department. And Hilda, who worked the cash register at a retail store in New York and needed a stool so she didn't have to be on her feet for 8 to 10 hours. And Tanya, a firefighter in Florida, who requested light duty status to avoid hazardous or dangerous calls. And Diana, a letter carrier in Minnesota, who was given a heat restriction by her doctor and needed to limit her time outside on extremely hot days. And Tisha, a retail store employee in Missouri, who needed to carry a bottle of water to help with her nausea and dizziness. These real-life stories are everywhere, and you can find more of them in reports and storybooks published by the National Women's Law Center, Moms Rising, and A Better Balance. We also believe that the need is huge. Next slide. We also believe that the need is huge, and there aren't hard numbers, but a 2013 study estimated that every year 250,000 pregnant workers are denied accommodations. And the National Partnership for Women and Families issued a report in 2022 that said nearly 2.8 million women were employed during their pregnancies and could benefit from PWFA's protections. So I mentioned a few of the stories earlier, but in your handout, and you know, my colleagues will talk a little bit more about the handouts, but in your handouts is an extensive list of needs, a more extensive list of needs and accommodations that you'll likely encounter. And I've listed some of them here, like light duty, a workstation near a restroom, needing longer breaks, working from home. But again, there's a much more extensive list in your handout. Next slide. Yeah, again, so as part of our education to get this bill over the finish line, we told members of Congress that when employers deny these requests for accommodations, they are forcing the worker to continue working and to put her pregnancy at risk. And she will do that because she is likely the primary breadwinner in her family and can't afford to go without a paycheck. When this happens, she could experience negative health outcomes, including preterm birth, miscarriage, and even stillbirth. If she's fired or put on unpaid leave, the stress and anxiety of being without a paycheck at a time when it's needed most will be overwhelming and harmful. We urge senators who cared about the shamefully high maternal mortality rate in the U.S., especially among Black women, to look at the failure to provide accommodations as one of the root causes of this crisis and to see PWFA as an appropriate federal response. Next slide. We also explained to members of Congress that passing PWFA was necessary because the current law wasn't working. The laws we have, the PDA, the ADA, the FMLA, and state anti-discrimination laws had many gaps that left too many women unprotected and forced them to choose between their jobs and a healthy pregnancy. And that was actually one of the things that we stressed over and over and over again, that no one should have to choose between a healthy pregnancy and a job that feeds her family. And in fact, when the Supreme Court came down with Young v. UPS, litigators and advocates had high hopes that Young would clarify employers' obligations under the PDA and result in more pregnant workers getting the accommodations they needed. That's not what happened. Employers kept denying accommodations and courts kept approving those denials. One of our PWFA coalition leaders, a national nonprofit advocacy group called A Better Balance, wrote a report showing that roughly 2/3 of plaintiffs in post-Young rulings lost their PDA pregnancy accommodation cases. So the current law simply wasn't working. We tried to allay lawmakers' concerns about creating a brand new workplace discrimination law like PWFA by reminding them that many employers were already providing these kinds of accommodations because they made good business sense and or because they operated in one of the 30 states, including red states, like North Dakota, Kentucky, Tennessee, West Virginia, and South Carolina that had already adopted Pregnant Worker Fairness Act laws. You know, ultimately the message we were sending is it was time for a uniform federal law that would cover workers no matter what state they lived in. Next slide. Another really key strategy that we developed to pass PWFA was to build a big, diverse, and powerful coalition that included the business community. I don't think we could have won. We could have passed PWFA without business support and without the U.S. Chamber of Commerce. The Chamber worked tirelessly on this campaign and made the case directly to members of Congress that PWFA would provide much needed clarity to employers about their obligations to pregnant workers. and would help employers retain talent, reduce turnover, and improve morale. And other business groups joined the chamber, like SHRM, National Association of Manufacturers, and the National Retail Federation, to name just a few. Next slide. And the National Partnership for Women and Families in the ACLU also organized a letter from 45 companies. And you see there's an excerpt from the letter on your screen, but then the list of all of the companies. And all of these businesses saw the legislation as a way to provide workers with the protections and opportunities they need to participate fully and equally in the workplace. And we shared this letter with members of Congress. Next slide. So our coalition was a force to be reckoned with. You know, I talked a little bit about the business support we had, but our coalition was pretty huge. We had faith-based organizations, labor unions, maternal health advocates, women's rights and civil rights organizations, and even Hollywood stars who did their own kind of separate letter, that was sent to members of Congress. All of these voices came together and demanded that Congress pass the Pregnant Workers Fairness Act, and you know, we're happy they did. And I have to say, it's not often that you find the U.S. Chamber of Commerce, the ACLU, and the U.S. Conference of Catholic Bishops on the same side of an issue, which is what happened in this case. And when that happens, I think it really elevates the issue. But even with that elevation, it was a struggle, and it came down to literally the last day of the 117th Congress. And there were many moments where we thought we weren't going to be able to get this over the finish line, but we never gave up, and we kept trying. And I'm really just really ecstatic about this legislation and the good that it will do. So I could spend hours, because there's so much more to say about this campaign. I could spend hours talking about PWFA, but I know I'm running out of time. But before I leave, I wanted to note one other legislation that passed on the same day. Next slide. So the Pump for Nursing Mothers Act also passed the Senate on the same day that PWFA did. It passed in the House in 2021 by a vote of 276 to 149, and passed in the Senate by a vote of 92 to 5, and was signed, into law on December 27th. And a smaller but equally hardworking coalition worked on this bill for a few years, and we're thrilled to see it pass. So in a nutshell, the Pump Act will give break time and private pumping space to employees who are nursing their children. The original law, called the Break Time for Working Mothers Act, was passed in 2010, but it excluded 9 million women of childbearing age from coverage, including teachers, registered nurses, and farm workers. It was also unenforceable in court, so for the most part ignored by too many employers. And the Pump for Nursing Mothers Act closed those gaps and made the law applicable to almost all employees, and gave aggrieved workers the right to sue for meaningful monetary damages. So keep an eye out. There'll be, I think, a separate webinar on the Pump for Nursing Mothers Act, and we're really excited about that law too. And with that, I say thank you, and I will pass it to Liz.
Liz,
Oh, you're on mute.
Thank you. Thank you, Vanya. I'm gonna figure out how to share my screen. Before I do though, I want to just acknowledge that without the brilliant and tireless advocacy of Vanya and the entire broad coalition that she shared with you all, we wouldn't even be here talking about these incredible new legal protections. And so I'm just very grateful to you and to the coalition for changing the course of history for millions of pregnant people, for millions of women, for their families, and proud to work with you. So let me see if I can share my screen here. Okay, looks like it is working. All right. Hi, I'm Liz Morris. I am the Deputy Director at the Center for Work-Life Law, and I am going to be providing an overview of the Pregnant Workers Fairness Act, or the PWFA, or as Vanya would call it, PWFA. And so we're going to cover now just what is in this law. Okay, so the law goes into effect on June 27th, 2023. Folks are going to have these new legal rights in just a few months. The Pregnant Workers Fairness Act uses a similar framework to the ADA, to the Americans with Disabilities Act. It adopts many of the same definitions and interpretations as the Americans with Disabilities Act. So attorneys who are already familiar with the ADA are going to have somewhat of a leg up in understanding this new law, and also are going to be hearing a lot of familiar terms today. And many of those terms do have the same meaning as they do in the ADA context, but important to keep in mind that many or some of the terms have slightly different meanings in the context of the Pregnant Workers Fairness Act. And that's one of the complexities that we'll be touching on in this webinar, but also diving into in more detail in webinars in this series. The statute directs the EEOC to issue regulations by December 27th, 2023. So keep your eyes peeled for that, and we will send an announcement when those come out, and I imagine also have a webinar about the new. Which employers are covered by the Pregnant Workers Fairness Act? The statute defines covered entities quite broadly to include almost all employers who are covered by federal anti-discrimination laws like Title VII. So that includes private employers of 15 or more employees, federal, state, and local government employers, employment agencies, and labor organizations. All right, so this provision is sort of the main show of the Pregnant Workers Fairness Act, the primary protection that people have. It is an unlawful employment practice to not make reasonable accommodations to the known limitations related to the pregnancy, childbirth, or related medical conditions of a qualified employee, unless the employer can demonstrate that the accommodation would impose an undue hardship. And so in the next 5 slides, I'm going to sort of unpack this and talk about what each of these highlighted phrases means in the context of the PWFA. So first, employers are required to make reasonable accommodations. And that means the same thing as under the ADA, and it includes those various accommodations that Vanya listed earlier, and of course, many more accommodations that may be responsive to an employee's needs. Want to flag for everybody, but that the Center for Work-Life Law has a document that explains why pregnant workers may need accommodations in certain circumstances, and also provides lists of accommodations that may be responsive to those particular circumstances. It's a really comprehensive 12-page document, and so it's included in your materials today, and encourage you to check it out, particularly if you're negotiating with an employer for an accommodation for your client. Okay, so reasonable accommodations have to be made for known limitations. What does that mean? A known limitation is a mental or physical condition that the employee has communicated to the employer. And we're going to talk a little bit later about what it means to have communicated the limitation to the employer. Note the statute is explicit that the limitation does not need to be a disability. It doesn't have to rise to the level of a disability like in the ADA context. It simply has to be a limitation related to pregnancy, childbirth, or related medical condition. So let's unpack what that means. This term is not defined in the Pregnant Workers Fairness Act, but it has been, the language has been taken from the Pregnancy Discrimination Act or the PDA. So we have years of interpretation from the EEOC and from courts telling us what this language means. Courts in the EEOC have interpreted it quite broadly. So it includes normal physical changes of pregnancy and childbirth. So anybody who's been pregnant or knows somebody who's been pregnant knows that there are many physical changes of pregnancy and childbirth. They can range from back pain, morning sickness, swelling, bladder control issues, and so on. All of those things are also complications of pregnancy and childbirth. And so that can include things like gestational diabetes, preeclampsia, prenatal or postpartum depression. There are also a range of related medical conditions that are related to pregnancy and childbirth that have been identified by the EEOC and some courts as also being covered. And that includes lactation, so breastfeeding, chest feeding, abortion, miscarriage and pregnancy loss, fertility treatment, and menstruation. Okay, so accommodations have to be made for qualified employees. What is a qualified employee? A qualified employee is an employee or an applicant who can perform the essential functions of the job either with or without an accommodation. So I think many of you know this language from the Americans with Disabilities Act context. It's very similar. And for folks familiar with ADA cases and litigation, you know that employers often successfully have cases thrown out by arguing that an employee who needs an accommodation is not qualified because they are not able to perform the essential functions of the job because of their need for accommodation. So perhaps the accommodation that they're requesting is to be excused from one of the job duties that the employer deems as an essential function. And so in the ADA context, this qualified employee and essential function piece can be a large barrier. However, in the PWFA context, the meaning of qualified is more expansive. And that is because in the statute, a little technological issue here. In the statute, an employee or an applicant who cannot perform the essential functions of the job is still qualified if, and these three things come from the statute itself, the inability to perform the essential functions is temporary, the essential functions can be performed in the near future, and the inability can be reasonably accommodated. Now, because pregnancy is temporary by nature, it's almost always going to be it is almost always going to be true that an employee who can't perform the essential functions is going to be a temporary thing, and so this will not serve as the same kind of barrier that it does in the ADA context. Okay. There we go. Okay, finally, accommodations have to be provided unless the employer can demonstrate, so this is an affirmative defense, the employer can demonstrate that the accommodation would impose an undue hardship. So Undue hardship in this context means the same thing as under the ADA, which of course is a significant difficulty or expense, which is considered in light of the size of the employer, their resources, the nature of their business operations. And as we'll discuss later, because pregnancy accommodations are typically temporary, it is going to be often unlikely that there will be an undue hardship. Okay, let's talk about the interactive process. The PWFA says that the employer and the employee will typically use the interactive process to identify an appropriate, reasonable accommodation. Unless the accommodation is obvious, and then no further discussion may be necessary. And the interactive process in the context of the Pregnant Workers Fairness Act has the same meaning as under the ADA. And so that means that this interactive process is going to typically include an analysis of what the employee's job duties are, what the essential functions are, while understanding that a temporary inability to do those is not necessarily a deal breaker. It's going to involve conversations, one or more conversations with the employee about what they can do, what they can't do, what accommodations may be responsive in meeting their needs. And it's going to include consideration, at least, of the employee's preference for which accommodation the employee would prefer. There are a few other unlawful employment practices under the Pregnant Workers Fairness Act to be aware of. First, it's unlawful to force an employee to accept an accommodation unless one has been requested and the employer has engaged in the interactive process. So if an employee did not request an accommodation, the employer cannot force one upon the employee, and the employer can't just force an employee to accept an accommodation of the employer's choosing unless it has gone through this interactive process to consider what the employee's needs are. However, employees are not entitled to their first choice accommodation. If there's some other accommodation available that will meet the employee's needs and is equally effective in allowing them to do their job, then it is the employer's decision which accommodation to provide. It's also unlawful to force an employee out on leave, whether it's paid or unpaid, if the employee doesn't want to take leave and another responsive accommodation exists. Remember, the purpose of this statute is to keep pregnant people working so they can continue to earn an income even when they need modifications to their job so that they can continue earning an income and supporting their family. So if there's some accommodation that will allow them to keep working, unless they've asked to be put out on leave, the employer can't choose to put them out on leave, even paid leave. And then finally, it's an unlawful employment practice to use retaliation or coercion against an employee or another individual related to requesting or using an accommodation or opposing unlawful practices. All right, let's talk about the remedies. The remedies of the PWFA mirror Title VII and other anti-discrimination laws that may apply to employees who are not covered by Title VII. And so that means that administrative exhaustion is required, whether with the EEOC, filing a charge with the EEOC, or filing a complaint with the relevant government employees Equal Employment Opportunity Office. The same damages are available as under other anti-discrimination laws. So remedies for employees covered by Title VII, for example, compensatory and punitive damages are available, except with regard to public employers, punitive damages are not available. And also the damages caps from Title VI in the PWFA context. And then finally, attorneys' fees and costs are available to prevailing plaintiffs. Be aware that there is a good faith defense to damages when the employer shows that it has made good faith efforts in consultation with the employee to identify and make a reasonable accommodation that would provide the employee with an equally effective opportunity. All right, last, I want to wrap up with a few more things that you should know about the PWFA. First of all, it doesn't limit state or federal laws that provide greater rights. So those state level PWFAs that Vanya mentioned earlier, perhaps the ones that apply to smaller employers or provide greater protections than the federal law, those are still in full force and effect. Also, employer provided health plans cannot be required by the PWFA to cover any particular treatment or procedure. That is not available under this law. And then finally, the PWFA adopts Title VII's exception for religious employers that shields them from religious discrimination claims for favoring co-religionists or people of the same religion. And that in Title VII is called Section 702. But note, federal appellate courts unanimously hold that religious employers cannot discriminate on the basis of sex, which of course does include pregnancy. So that is the PWFA in a nutshell. We're going to delve into all of these provisions more deeply in future sessions of this webinar series. Our goal is to help you to represent your clients, for example, with filing charges, with rebutting common arguments against reasonable accommodation. And so please keep an eye out for announcements from about the series, about upcoming webinars. And always, please feel free to reach out to us at the Center for Work-Life Law or at the ACLU if we can be of help. I'm going to pass it over now to my absolutely brilliant colleague, Cynthia Calvert.
Thanks, Liz. Wonderful. On the Work-Life Law Hotline, we've been working for a couple of decades to get accommodations for pregnant and breastfeeding employees. And we've been using whatever statutes we could grab, the PDA, the ADA, the FMLA, and state and local laws. And Jillian and the ACLU have also been working hard. They've been litigating accommodation cases for about 15 years, sometimes in partnership with Work-Life Law and sometimes in partnership with other participants in this session. And while we've had many good successes, unfortunately, the patchwork of laws has had a lot of holes, and some employees have had to quit or they've been fired because they needed accommodations they couldn't get. So we are so happy, we are so grateful to have the PWFA, and we've been studying and planning, and we are ready to hit the ground running just as soon as the PWFA becomes effective. So what I'd like to do now is to share with you what we've learned from all of our experience and how we plan to advise callers who need accommodation going forward once we can use the PWFA. May I have the next slide, please? The PWFA doesn't require employees to use any particular words to make their employers aware of their limitations and the fact that they need an accommodation. It's just important that they make the limitation known to the employer. They don't have to give a lot of detail. They can say very simply something like, I have swollen feet, and that makes it hard to stand. And it doesn't have to be the employee who's doing the communicating. It can also be the employee's representative. It could be a partner, a spouse, a friend, but it also could be a lawyer or a doctor. Next slide, please. And when they make their limitation known, they need to communicate that there's a link to pregnancy, childbirth, or a related medical condition. And again, it can be a very simple communication, no special words. They can just say, due to my pregnancy, or following my miscarriage, or because I recently gave birth. Next slide, please. It does not have to be in writing, although our years of experience suggest that it is very helpful to have it in writing. A lot of times, disputes will arise about whether an employer was told something or when the employer was told something. A lot of employees use email because that's what they're most familiar with. That's how they usually communicate with their employers. But we expect in the future going forward, a lot of employers will use request forms. We do see that already with people who are asking for pregnancy accommodations under the patchwork of laws. They're often told to complete ADA forms. And a lot of times they're told to get doctor's notes. We do expect that that's going to continue as well under the PWFA. Next slide, please. Now, the employee, when making the accommodation request, does not have to suggest a specific accommodation. However, if they do have specific ideas that they can suggest to the employer, that's going to speed up the process, and it's going to greatly increase the chances that they're going to get the accommodation that they want. Next slide, please. We've given you, as you've already heard, some sources for ideas for accommodations in the handouts. The two I'd like to point out particularly are the pregnancy accommodations explanation that Liz showed you a picture of earlier. It's extremely helpful if you don't understand what a particular condition is, or you need some additional information to share with an employer. It's got it, but then also for each condition, it breaks down what different accommodations would be helpful for overcoming that particular limitation. Also, Ask Jan, the Job Accommodation Network, has great ideas for accommodation. It's focused on the ADA, but also has accommodations for pregnancy. We've provided the link to that in your handouts on the resources page. Next slide, please. So when we're brainstorming with callers to our hotline, one approach we take is to think about the goal and not the job description. If we have a caller, for example, who can't carry, and yet their job description says carry boxes from point A to point B, we focus on the objective, which is moving the boxes rather than on the word carry. So boxes can be moved by a dolly or a cart. There can be assistance of other workers. There are many different ways to get boxes from one place to another. Next slide, please. And if that is not acceptable to the employer, we explore restructuring the job. If carrying is not an essential function, then we suggest removing it from the tasks that the employee has to do. But if it is essential, we still suggest, or we plan to suggest under the PWFA, that the carrying tasks still be removed, because as Liz told us, workers are still qualified under the PWFA if their inability to carry out, I shouldn't say carry, this punny, but their inability to do a function is temporary, and they're going to be able to do it in the near future, and the inability can be accommodated. So there are many ways to restructure a job. Tasks can be traded with a coworker who can carry. So maybe the coworker does all of the carrying and the employee does the coworker's paperwork. Or a job can be restructured so that the employee is not necessarily trading with one coworker, but all of the tasks required carrying get removed from the job description, and then the employee does the paperwork or whatever can be done in a seated position, and then the employer divides up the carrying tasks among the other employees who can carry. Next slide, please. And if that doesn't work, if the employer does not agree to that as an accommodation, the employee can suggest light duty or transfer to another position. As we heard from Liz, leave is a last resort, and only if there's no other way to accommodate the employee. That is, of course, assuming that the employee doesn't want leave. Sometimes that really is the best accommodation for an employee, but it should be their request. Next slide, please. And it's important, we've learned this through our years of experience, it's important to make sure that the accommodation that the employee is suggesting is possible. So if they want to move to another office, for example, there has to actually be a vacant office to move to. And if they want to transfer to another position, it's important that there actually be a vacant position that they can move to and that they are qualified to have that position. Next slide, please. If the employee can present several different options to the employer, it's very beneficial to them. Just on a practical level, it's going to increase their chances of reaching an agreement. And we often help them rank order their different suggestions so that they're starting with what they want most, and then they have several fallback positions. But also from a legal point of view, it's important because it's going to provide evidence that there were several ways that the employee could have been accommodated. A lot of times we hear arguments from employers that there was nothing that was possible. Well, if the employee has come up with several options, that's going to will diffuse that argument. But also, if you have an employer who is repeatedly denying all of the suggestions, then it could be evidence of lack of good faith. Next slide, please. And like the ADA, under the PWFA, the employee and employer are supposed to use an interactive process. It's a very informal process, and it's necessarily going to vary with the circumstances. So if it's going to be something that's very obvious, simple, easy to provide, if the worker needs a chair, more breaks, a water bottle, there really isn't going to be a lot of need for discussion. If the limitation is not obvious, if the person is asking for a more complicated accommodation, then you can expect that the employer is going to have a more formal process and will probably be documenting every step of it. Next slide, please. An employer may ask for medical certification if the need for accommodation isn't obvious. Under the ADA, the employer is entitled only to limited medical information, and that is information that's job-related and limited to business necessity. We've seen a lot of employers ask for entire medical files of employees who are asking for an accommodation, and we've had to step in and tell the employer that that is overreaching. We plan to be doing the same thing under the PWFA. The employer may have a medical certification form, like an ADA form, to be filled out, or may ask for a doctor's note. In that case, we would refer you to Work Life Law's note writing tool on the pregnantatwork.org website, and the link for that is in your handouts. It's a terrific tool that makes sure that the doctor provides to the employer all of the relevant information to document what the employee needs, but does not provide too much information, doesn't provide information that the employer is not entitled to. And for some of the states, there's actually a fill in the blanks form, which will make it even easier for the doctor to complete the note. Next slide, please. So if the employer rejects the employee's suggestions or if we're in a situation where the employee doesn't make any suggestions at all, the employer should be taking the reins, should be offering an accommodation that it can provide. And as Liz told us, just like under the ADA, the employee is not entitled to their preferred accommodation, but it is something that the employer should consider. And the employer can't force the employee to accept an accommodation unless they've engaged in the interactive process. Next slide, please. So if the employer rejects all of the suggestions, one of the things that we tell employees now, and we'll probably continue to do this, is see if other employees are receiving accommodations that are similar to what's been requested. So the reason for doing that is if the employer is providing it for other employees, it shows that it's a reasonable request, reasonable accommodation. And also, if there is going to be litigation later on, perhaps it's under the PDA or the ADA, this will provide evidence of comparators that will show what other people were being allowed to do. Next slide, please. And I have a suggestion for employers, which is if an employee requests an accommodation, do respond quickly and look for an accommodation that can be provided while the interactive process is going on. So the employee can continue to work and can continue to be safe. A delay in providing an accommodation can be really risky. It could constitute a denial of the accommodation. It also can be evidence of a lack of good faith. Next slide, please. And if you do have people calling you and asking for assistance in getting pregnancy accommodations once the PWFA goes into effect, or really at any time, please feel free to refer them to our work-life law hotline. We talk about legal rights with them and we help them figure out what to request in terms of accommodations. We also help them decide how to negotiate, what different tactics to take, and what to do if they find out the employer is just rejecting all of their suggestions. So the contact information is here on your screen. It's also in your handouts on the resource page. May I have the next slide, please? Okay, and now I will turn it over to Jillian.
Thanks so much, Cynthia, and thanks to all of you for joining us. I'm Jillian Thomas. I'm a senior staff attorney here at the ACLU Women's Rights Project, and I am one of those unfortunate litigators whom Vanya referred to, who has been litigating and often losing, sadly, these cases brought under the PDA for close to 20 years, sometimes working in co-counsel relationships with many of the people on this webinar. So I am joining the chorus of thrilled litigators who knows the immense good that this statute is going to do for our clients and for our work in this area. So as has been discussed, the PWFA expressly says that it does not displace statutes of equal or more generous provisions and different provisions. And so I'm going to talk just a bit about the practical consequences with respect to the different statutes that remain in effect in this area. There was a question in the chat about whether PWFA in some way displaces the PDA, and it definitely does not. And so let's go through that. The one other thing I would say, I would urge you to take a look at the scenarios that have been included in your handouts. They are, after you get over the PTSD of the issue spotting that is included in them, they really are invaluable in helping us see the many different statutory protections that are now in play. The Venn diagram is really quite extensive at this point and again, offers a lot of opportunity. So I'm going to focus in my brief discussion before we get to the Q&A section of our program on the PDA, the ADA, the FMLA, state and local PWFA laws, and the Pump Act. And the caveat with the Pump Act is that we are going to have a separate training in this series that really delves into the Pump Act. There's some information in your materials about it, but I will give a little bit of an overview about the ways in which PUMP supplements the protections of PWFA, PDA, well, really all of these other laws. Okay, next slide, please. So the PDA, as many of you who practice in this area know, it's a rather unusual creature in that it has two different clauses. Clause 1 is the clause that clarifies Title VII's definitional section. So Title VII's ban on discrimination because of sex includes discrimination because of pregnancy, childbirth, and related medical conditions. And Clause 1 is really pretty much unaffected by PWFA and was not really the target of PWFA. So think of Clause 1 as sort of the more plain vanilla kinds of pregnancy discrimination. You know, we're not going to hire you because you're pregnant. We're firing you because you're pregnant. We're not going to promote you, and so forth. And then Clause 2 is the one that those of us who have been working in this field, in this area of pregnancy accommodation, have been really wrestling with for so long. It requires employers to treat pregnant workers for all employment-related purposes the same as others similar in the ability or inability to work. And it was that last phrase that has tied up the courts and tied up employers and made things pretty difficult. Employers were making a lot of decisions about who was similar in the ability or inability to work and extending accommodations on a comparative basis in reliance on that language. So as we note here, PWFA largely displaces Clause 2 as the vehicle for bringing failure to accommodate claims. As we'll see in the next slide, it still remains quite viable. So why would we still use the PDA? I want to just flag this language that is in both statutes, in the PDA and in the Pregnant Workers Fairness Act, that what is protected is pregnancy, childbirth, and related medical conditions. And that, as Liz noted, that phrase has been interpreted extremely broadly, both in the case law and by the EEOC, and that is one very positive development from the PDA that we should celebrate and should utilize in our accommodation claims. So what remains, or why does the PDA continue to be a good vehicle for us? Well, Clause 1, as I mentioned, covers pregnancy discrimination as well as harassment and other terms, conditions, and privileges of employment discrimination. So that is not reached by the PWFA at all. The hiring and firing claims, the promotion claims, and so forth, not to mention harassment. And then Clause 2, why would we still use Clause 2? Well, there might be some ways in which your client falls through the cracks in some way of the protections now provided under the PWFA. For instance, for some reason or another, your client's limitation was not known to the employer, or at least the employer is taking that position. So you can look to whatever procedures the client's employer might have in place for accommodations of others similar in their ability or inability to work, and then use those procedures as a backstop for getting to achieving accommodations. In addition, the use of the disparate impact model to challenge otherwise neutral policies that may fall more harshly on pregnant workers needing accommodation. Very common example would be attendance policies that are very rigid, for instance, or policies forbidding taking any sort of leave or sick days within the first year of employment, for instance. There could still be arguments that that kind of neutral, facially neutral policy it falls more harshly on pregnant workers or workers needing accommodation. And then also the clause 2 of the PDA has always been the clause that deals with employer fringe benefits. So for those of you with knowledge of history, the PDA was enacted in response to the General Electric versus Gilbert decision in 1976, where the court found that it was perfectly permissible for an employer to carve out of an otherwise comprehensive disability benefits scheme, disability benefits for people who were out of work during recovery from childbirth. The court approved that. The PDA was a response to it, but that was really the genesis of Clause 2, and that remains in full effect and very much alive and should be used. One other thing to keep in mind with the PDA is that there's no good faith defense available to an employer. So that's another way in which the PDA remains viable in accommodation cases. Why don't we go to the next slide, please? The Americans with Disabilities Act. You've heard today that although pregnancy by itself is not considered a disability, and that's been longstanding, including from the EEOC, many pregnancy-related conditions could be considered disabilities. And I would commend to you, in addition to the extremely comprehensive materials that have been provided in connection with today's webinar, that you take a look at the EEOC's enforcement guidance on pregnancy discrimination. It's getting a little moldy at this stage, but it still has an extremely extensive discussion of the kinds of pregnancy-related conditions that not only does it consider disabilities, but that courts have found to be disabling. And additionally, there might be an issue where a pre-existing disability has some sort of interaction, is somehow exacerbated, for instance, because of pregnancy. One example would be somebody who has to be on certain medication to control a disabling condition, but because of safety considerations for the developing fetus, goes off of that medication, and then that develops, so that interaction of circumstances can develop the need for different kinds of accommodation. Next slide, please. So why do we still use the ADA if, as you've been hearing for some time during this presentation, the PWFA is modeled on the ADA and intended to lift many of the same concepts? Well, there are other protections in the ADA that are not included in the PWFA. For instance, the the ADA protects people who are regarded as having a disability or perceived to have a disability, really to basically address the stereotypes about various individuals and whether they actually do have a disability. Then it also protects individuals who have a record of a disability. So someone who may have had pregnancy complications in the past, needed bed rest during a pregnancy, isn't pregnant now, but is experiencing adverse action based on that, having a past record of a disability. Of course, just as Clause 1, pregnancy discrimination claims, discrimination harassment claims remain alive and well, so do disability discrimination or harassment claims. So we're not promoting you because you're pregnant and you have developed preeclampsia or diabetes, or harassment based on a pregnancy related disability. And then the ADA also has provisions that are lesser, has a provision that is lesser used, but could arguably apply in the pregnancy context, which is the associational discrimination claim. And so you could use the ADA to challenge a situation where a worker has a family member who has a pregnancy-related disability and is going to need care, for instance. There could be adverse action taken on that basis, and the ADA would be the vehicle for challenging that. And then the last thing I'll mention is that while there is mixed ADA case law in certain areas of the law, there are some jurisdictions that actually have issued extremely expansive readings of certain provisions of the ADA, such as holding that the failure to engage in the interactive process is its own standalone disability discrimination claim, or that an employer that takes unduly long to engage in the interactive process or identify a reasonable accommodation could be held liable for that failure as well. So those are all different ways in which the ADA might be an excellent complement to a PWFA claim. Next slide, please. The Family Medical Leave Act, or FMLA for short, I'm sure is fairly familiar to people on this webinar, but it's the best we've got on the federal level, for better or for worse, when it comes to time away from work for either self-care or family care. So it provides up to 12 weeks of unpaid but job protected leave in any 12-month period for those who are eligible, and eligibility depends on having worked for the employer full-time for a year, and then whether the employer is qualifying. So it has to have at least 50 employees within a 75-mile radius. So it's the biggest employers. And as many of you on this webinar likely know, as upwards of 40% of the workforce is not protected by the FMLA because of these eligibility requirements. So what the FMLA provides for is time off for the worker's own serious medical condition, and pregnancy constitutes a serious medical condition, the serious medical condition of a spouse, child, or parent, birth of a baby or care of the newborn, or baby bonding. So not just recovery from childbirth, but baby bonding, as well as bonding with a child placed through adoption or foster care. One thing that the FMLA does provide is that the leave may be taken intermittently in increments as small as 1 hour. So for instance, to attend prenatal appointments. And then it provides 2 different routes for bringing a challenge. There's interference with rights under the Family Medical Leave Act that does not require any showing of intent. And then there's retaliation for having utilized FMLA rights, and that does require a show of causation, just like any other retaliation claim, and may be rebutted by the employer with a legitimate non-discriminatory reason. Next slide, please. So why would we use the FMLA? In most cases, we would argue that time off, whether it's because a worker is late due to morning sickness, or whether it's a more prolonged period of absence due to pregnancy, we would say that that displaces the need for taking FMLA. But the FMLA still remains critical for leave unrelated to one's own pregnancy-related care. So if there's self-care for a serious medical condition that's unrelated to pregnancy, a family member has a serious medical condition, or for the time off for, as I mentioned, the baby bonding, adoption, or foster care bonding, none of those kinds of time off are covered by the PWFA. Next slide, please. State and local PWFAs, as Vanya mentioned at the outset of our program, many states and localities stepped into the breach over the past several years, given the PDA's gaps in application by courts. And so more than 30 states and localities, in fact, have these protections on the books. So why would you use a state or local PWFA, given that we now have this fabulous federal statute? Well, as we've noted, the federal PWFA allows for laws that have greater protections to apply in such circumstances. And so, for instance, there are state PWFAs that have that cover much smaller employers. Here in New York, for instance, the pregnancy accommodation statute covers employers that have just one employee, as opposed to the 15 covered by the PWFA. Some have more generous substantive provisions, so they may not require an interactive process, at least with respect to certain kinds of easy to make accommodations, whether that's transfer to an open job or something as minor as carrying a water bottle or occasionally sitting down. There are some state PWFAs that that forego or do away with the interactive process in those circumstances. There are some state laws that have no undue hardship defense available to the employer. Other laws may dispense with the medical certification requirement for more minor accommodations. Also, some state and local PWFAs don't have damages caps, unlike the PWFA. They may have longer statutes of limitations, which is always a bonus. And then I've not noted here, but just obviously there are other protections for pregnant workers in state anti-discrimination laws. Again, with respect to the disability issues that we've covered, where there might be an intersection between disability and pregnancy, or pregnancy actually causes a disability, as well as good old-fashioned sex discrimination claims, caregiving discrimination claims. So there's a wide range of protections where states and localities have really been ahead of federal law in certain respects, and may actually, in their provisions, be explicitly broader. Next slide, please. Finally, I'll just, as I noted, just make a couple of notes about the Pump Act's interaction with PWFA, because under PWFA, where related medical conditions must be accommodated if it wouldn't pose an undue hardship, the PDA has long held that lactation is a pregnancy-related condition, and that remains the same. But the Pump Act is another incredible victory that is really changing the landscape for pregnant and parenting workers. And so here are just some of the wonderful ways in which it broadens existing protections. It applies to employers of all sizes. So again, PWFA is limited to employers of 15 or more. There's no undue hardship defense if the employer is an especially large employer of 50 or more. It specifically mandates the accommodation last for 1 year. The PWFA does not, as has been discussed, does not have any sort of particular time frame that it mandates the accommodation for. It specifically mandates the parameters for the pumping location and the frequency. So the PWFA would allow someone who needs to pump the ability to say, I need time to pump, but then it's going to be up to the interactive process to determine the parameters of that. Pump dictates that that location cannot be, that is granted to a worker, cannot be a bathroom, and must satisfy other various other criteria in order to be suitable. And then finally, there are certain additional remedies in Pump, most notably liquidated damages with respect to lost wages, which are not provided for in PWFA. So in addition to the resources that are included in today's materials, I would urge you to take a look at the Department of Labor's website, Department of Labor, because Pump amends the Fair Labor Standards Act. That's the entity that enforces it. And then also an explainer that the ACLU and the Center for Work-Life Law, along with many other organizations listed here, put together in the aftermath of the Pump's passage to give sort of a primer and a placeholder until we're able to offer a more extensive training, which we promise will happen sooner rather than later. Next slide. So this is all of our contact information. We are always interested in hearing about your cases, helping you talk them through. If, as Cynthia noted, you need help getting legal counsel, work-life law in particular can help you with that, both through their hotline and also through individual contact. And we are done.
Thank you, Jillian. Thank you all so much.